Hello and welcome to my assignment 2. So for assignment 2, I decided to compare some legal cases, their decisions, and essentially discuss what the implications are for me as a Ontario certified teacher. Honestly, I don't know why I went down this avenue because it took me a long time not only to understand the legal jargon, but also read through the numerous pages of the court documents. But anyways, without further ado, here we go. So this case is a little quick background. It's a Supreme Court case, and it's the case. It happened in 2016, and it's between ET and the Hamilton Wentworth District School Board. So a little bit of case background. The applicant in this case was a male who had two children at a school on the Hamilton board, and based on their tenets of his religious beliefs, he states that these contradict various aspects of the public school curriculum. So the applicant wanted accommodation from the board in order to essentially stop or be able to pull out his children from classes which he said exposed them to false teachings regarding human sexuality. He also stated that various aspects of the board's equity policy exposes children to materials regarding human sexuality which are sinful, such as same-sex marriage, and you know. He also stated that there's only two genders, i.e., male and female. So he was really opposed to that based on his religious beliefs. Like, he was opposed to his children being exposed to that material based on his religious beliefs. So what he wanted was essentially a declaration from the Supreme Court that he had final authority as a parent over the education of his children, and he wanted the board to not only like provide him information in advance to when such materials were presented, which obviously as a teacher or there was a teachers federation also involved as an intervener in this case. So this stipulation to provide him advanced information to materials or classes that could have information which goes against his religious beliefs, that would be very impractical and tough to do as a teacher. You can't advise a parent every time you're about to teach something on sexuality or non-heterosexual behavior and stuff like that. So yeah, he wanted advanced information to specific classes which conflicted with his religious views so that he could withdraw his children from them. So he stated essentially two freedom infringements. So the first basis for requesting accommodation, he asserted that it infringed on Section 2A of the Canadian Charters of Rights and Freedoms, which deals with his freedom of to express his religion. And his secondary basis for requesting accommodation was his assertion that without this accommodation, his right to freedom from discrimination on the basis of creed, which in the Ontario Human Rights Code, creed is purposely left out just as creed, which also deals with beliefs, religious beliefs, but Ontario specifically chose to put creed rather than religious creed because they wanted to encompass a broader sense of what that meant. It was very tough for me to actually define creed, and because I read about it and it's very confusing, but essentially creed encompasses anything from religious to non-religious views and beliefs. As long as you firmly believe in something, and there's other organizations that share these beliefs and you're deeply entrenched in it, then that is a creed, or at least that was my understanding of it. So what the applicant wanted was declaratory order to support his main claim that he can assert his charter and code rights when pulling out his children from classes without the board asserting a superior level of authority when it came to his children's education. And the Superior Court's decision essentially hinged on whether it was appropriate to invoke this right or to declare this right, whether it was appropriate or necessary for this declaration to be made. So there were a couple of cases that I wanted to mention which factored into this decision by the justice of this particular case. So essentially what he said is that like accommodation by non-attendance, so by pulling his children out as sought by the applicant, would allow him to isolate his children from parts of the curriculum. However, this is antithetical to charter values favoring inclusivity, equality, and multiculturalism. So by taking his children out, you're actually going against the charter values which favor inclusivity and equality and multiculturalism. So on a separate case, Justice Deschamps, on behalf of the Supreme Court of Canada, said that parents are free to pass their personal beliefs onto their children as they so wish. The early exposure of children to realities that differ from those in their immediate family environment is a fact of life in society. Suggestions that exposing children to a variety of religious facts infringes on their religious freedoms or of their parents essentially amounts to a rejection of the multicultural reality of Canadian society and ignores the Quebec government's obligation with regard to public education. So this was a decision in a Quebec case. And then this one's pretty long. This was in a separate case where Chief Justice McClellan was advocating for cognitive dissonance, in which he states that essentially because there's so many different family models in the community, it's inevitable that some children will come from families which certain parents disapprove of. Giving these children an opportunity to discuss their family models may expose other children to some cognitive dissonance. The cognitive dissonance that results from such encounters is simply a part of living in a diverse society. It's also a part of growing up. So the exposure to some cognitive dissonance is arguably necessary if children are to be taught what tolerance itself involves. Then he or she went on to discuss what exactly tolerance is. So tolerance can't be interpreted as the demand to approve of another person's beliefs or practices. When we ask people to be tolerant of others, we do not ask them to abandon their personal convictions. We merely ask them to respect the rights, values, and ways of being of those who may not share those convictions, which I thought was super important and a really good definitions of what tolerance means. The belief that others are entitled to equal respect depends not on the belief that their values are right, but on the belief that they have a claim to equal respect regardless of whether they are right. So I thought this was very pertinent because even though the applicant's views on sexual orientation and genders and stuff like that conflict with those that his religion dictates, tolerance doesn't mean that he has the ability to say those are wrong and ours are right, but to show equal respect for those views which oppose his religious ones. So in conclusion, what happened was because the applicant was still able to articulate and advance his religious beliefs upon his children, regardless of the board presenting diverging views, the justice chose not to exercise his decision to grant declaratory relief requested by the applicant. So they did not side with the applicant in this case. And the ability to articulate and discuss potential situations like this one, which could arise in future practices, for example, facing pressures from parents to not include certain curriculum or to exclude their kids from particular curriculum. As a teacher, knowing this type of decision and knowing that these cases have gone to the Supreme Court of Canada and they've deemed that it's not infringing on anyone's beliefs, infringing on anyone's religious beliefs to present alternative views, as is mandated by the Ministry of Education in their equity policy, provides teachers with not only confidence that they're doing the right thing, but also that in the eyes of the law, they are correct. And I think that's the most important part. So This video is doubled in time, and I fully apologize. There was a lot to talk about there. I try to keep it as brief as possible. These are my resources. So the E.T. versus Hamilton District School Board case, the Chamberlain versus Surrey School District Board, and Jaffer versus York University. Thank you very much, and all the best.